Hello, everyone. Welcome to the June edition of the WBA Compliance Corner. For those of you who are new to this series, this is a monthly video series with hot topics updates that Heather and myself bring to you from the legal department and happenings within the compliance world. These are designed to be about 30 minutes or so, depending on how much happens during a month and what we have to bring to you. But we like to keep it short and have it something where you can get a condensed amount of information for what's happened during the previous month. And so what we do is give a previous summary of each issue. And on the slides, what you'll see is that there will be items that are marked with an asterisk. And those are going to have a link in the description below that you can follow to get more information. So first, let's look at a summary of what we're going to talk about in this month's Compliance Corner. We have an update on FDIC Representment guidance, and so that'll be the first topic. So we'll talk about that in just a moment, but this is a clarification that FDIC made on look-back periods. We also have some updates on third-party vendor management, including interagency guidance and a risk management toolkit from the Financial Stability Board. Some real estate related updates as well, including new proposals for automated valuation models and reconsideration of value, as well as some new PAVE appraisal bias initiatives that ties into that. And you'll see more once we get to that item. And then we'll wrap up by looking at some CFPB items, as well as some updated agency manuals and additional items. And then we'll talk about a recent update to Wisconsin's IOLTA rules. So with that in mind, we will get started with our first item on slide 3 here. And so this is the representment guidance that we had mentioned regarding FDIC. And so last year, I'm sure most, if not all of you will recall, we had FDIC supervisory guidance, and we talked about this on a few separate occasions, but this was the issue related to multiple representment fees and the issues that you were also facing then with FDIC looking at that in exams really across the board. And much of that then in turn involved a review of your deposit account documentation, specifically looking at representment fees. So what you had within your terms with your customer, but also what your practice was, and then primarily how you were disclosing it. And the issue, of course, being FDIC looking to see if this was fair, if it was something that was clear to the customers and those disclosures were something that could be understood, and your consumers, your customers would know how those representment fees were going to be charged if that was something that your bank was doing. And so now nothing here in this item that we have for you today necessarily changes that. It doesn't reopen it, so to speak, but it's a small clarification that was made in a footnote here to the existing guidance that we've all reviewed, but it's an important one in the legacy of all of this that we've had going on. And so the link again to the full updated guidance is in the description below, but really the change is just on the slide in front of you too. We've got the full clarification right on the bottom here. And so to explain that, in the previous guidance, there was a footnote. And within that footnote, FDIC discussed this concept of a look-back period, but it didn't necessarily clarify it. And the fact that it was in a footnote as well maybe left some unanswered questions. But I know that many of you were questioning whether you should do a look-back period, how long it should be. And again, we talked about that in more detail in the past. But now we have this updated guidance from FDIC. So since adding this footnote, FDIC has stated that since the issuance of the original guidance, it has gathered additional data regarding consumer harm associated with the issue and its experience in exams, and has since decided to clarify its current supervisory approach to not request a look-back review unless there's evidence of substantial consumer harm. So in essence, what we have here is again, the legacy of this whole issue of FDIC having gone through all these exams, having gathered data, kind of consolidated all of that, and decided that based upon what it's seen throughout its experiences regarding this issue, that it is not going to require a look back. Of course, there could still be situations that mandate it, such as if substantial consumer harm did exist. But as a general matter, that clarification within the footnote is now present in the guidance. So again, while we suspect that you have all addressed this issue, it's nice to have this clarification on the matter. If it's something that you were still questioning, whether you needed to do a look back period, or maybe you did do a look back period and you were wondering, well, we went back a month, we went back 2 months, we went back a whole year. Was that enough? Did we need to do more? Hopefully that adds some additional clarification on the matter, on the question of look back period, as we know that was on many of your minds. So with that, I will turn it over to Heather to cover some third-party risk management.
Super. Thank you, Scott. And yes, the agencies have updated and released a one-stop fits everybody guidance, meaning that previously the agencies had their own separately issued guidance on the third-party vendor management rules that they expected you to work through. And with this new guidance, they've rescinded those independently released guidance items and issued this interagency third-party vendor management guidance. And so this new guidance is meant to completely replace the previous guidance. And the agency has also incorporated into this guidance several separately issued FAQs that the OCC had been using in the past. So it really is helpful to have everything all in one place, all to be talking from the same guidance. And so you're going to want to read through that and just brush up where you may need to some of the nuanced messaging that is within this new third-party guidance. It's very straightforward. It is meant to help institutions of every size, and I think that they've done a pretty good job updating it. They started the process back in 2021, and so we're happy to have this out and something for you to work with. If you have any questions when you work through that, don't hesitate to ask Scott and myself. We can walk you through certain parts of that particular guidance. On a similar tangent, so for those of you that vendor management is a task of yours to manage and make sure that your third parties are all adhering to, you're also going to want to know that the Financial Stability Board, so on the next slide, you will find that we also wanted to include an additional resource. This Financial Stability Board, if you're not familiar with them, they're a global organization that works with all different parties within the financial system, so banks and vendors and processor systems and what have you, looking at holistically how to have a thorough discussion about third-party vendor management without having it be disjointed between the different types of financial products and services that are out there. So this group has put together a 4-chapter toolkit, and the toolkit is really meant to take that holistic approach and look at vendor management from the eyes of both the industry and from the supervisory approach. So it doesn't replace the guidance that I just spoke of. It's meant to supplement that recently released guidance. But again, for those of you that are needing to manage your third-party vendors, there'll be some actual helpful tips within this toolkit that would be something to also consider when you're working with those third parties. So we just wanted to make sure that you're aware of that and have provided the link below for you. So with that, I'm going to turn it back to Scott.
Great. Thanks, Heather. So on this slide, we've got 3 items for you, but they all kind of tie together. And so these are related to a few ongoing real estate related matters that we've been tracking and discussing as we've been going along too. So suspect that this will not come as a surprise to most of you, but we do have some updates on the overall push for fair housing that the current administration has been working on. And so, for example, the first one here is a proposed rule, interagency rule, to create quality control standards for automated valuation models, or AVMs. And so, in short, this would require adoption of policies, practices, procedures, and control systems to ensure that AVMs adhere to certain standards. Now, there are no specific standards in here, so it's matter that your bank will have to look through to see how you use those AVMs. And we're really seeing AVMs used more and more. And of course, as an electronic method, it's certainly appealing in that regard as well. But the idea here is making sure that they're accurate and fair by creating standards that can establish a consistent level of confidence in their use. And so that's really the goal here. And that's why, again, there are no specific standards, but it's a matter of saying that these are out here, they're being used more frequently, but in electronic systems, there needs to be certain levels of control in place. And so through those controls, again, which might be appropriate for how you use them, when you use them, what your policies are, tying in a more consistent approach to have that level of confidence, not only within the industry, but for consumers as well. Again, the overall push here being the theme of fair access to housing. And so we wanted to see that across the board when it comes to usage of AVMs. Then we also have interagency guidance on reconsiderations of value on residential real estate valuations. So we talked about this issue a little bit last year as well. And the idea for this one is that there be some guidance regarding setting policies to allow consumers to challenge, so to speak, an appraisal for deficiencies by providing information that might not have originally been considered by the bank, or again, maybe questions of deficiencies in there. But that's the reconsideration. So when there's a valuation that comes in, that the financial institution actually have a process in place so that the consumer could follow those channels. So know how to notify, how to start that process, who to work with, what to bring, and present that case for what the deficiency might be or what wasn't considered in that value. Again, that then triggering that reconsideration. So the guidance then is on when an ROV might be considered based upon certain information that's provided by the consumer. And again, the key here for that is, in short, establishing a process for that. Another point that's worth mentioning here is that this also intersects with appraisal independence requirements. The guidance does discuss that as well. So again, the guidance provides those considerations for the development of your own ROV procedures alongside an awareness of that existing interagency appraisal and those evaluation guidelines. So if you already have these in place, right, the guidance is going to consider that. And again, this is guidance. It's meant to help focus that approach, or if you don't have one, to help build one or help shore it up, and perhaps to bring it in line with those overall interagency appraisal guidelines as well, if that's something that you've been relying on more specifically for your ROV process, as that's not discussed as expansively as it is within this guidance. Then lastly, we wanted to talk about the continued efforts regarding fair access to housing and the PAVE initiative, so the Property Appraisal and Valuation Equity Task Force. This was a task force that was put together by the current administration, again, with the goal of fair access to housing. But specifically here, the efforts are directed toward that valuation equity. So in short, efforts to combat appraisal bias. So this is, of course, one of the current goals of the administration, and we see this through the efforts of the task force. And in the link in the description below for this item, you'll see the 4 items from an update from this task force and what they've been working on. 2 of them, the very first 2, are the guidance, the rules and guidance that we just discussed. So AVMs and the ROVs. So preventing algorithmic bias is the idea here, right? Looking at those electronic algorithms, making sure that there's no bias in those systems, being able to have consistency and confidence in using them, giving consumers then the ability to take their own action against appraisal bias as well. Empowering consumers is really the part of that and the goal of that with the ROV process. Then you also see discussed within their PAVE has been gathering a lot of data, right, to support these initiatives, to see what's been working, what needs to be done, and providing more information and tools as well to those who are interested in the appraisal industry overall. And really what this last initiative is, and the last bullet point is PAVE is trying to give opportunities to those who might want to be involved in the appraisal industry. And so making it clear what the appraisal industry is, what that path is like, and providing those resources to those who might want to be involved in that. So all of that information on this slide ties to those efforts. Everything you see on this slide ties into PAVE's overall efforts. And again, that fair access to housing. And you can find the links to all three items in the descriptions below, right? So the proposal for the AVMs, and then the guidance for the ROVs, and then a link to the update from the PAVE initiative as well. So with that, I will turn it back over to Heather.
Thank you, Scott. We also wanted to make sure that you were aware of some recently issued items from the CFPB. The first one deals with chatbots. So these are the cute little figures that come up when you're on a website, usually pretty comical little face or some fun little name that might be attributed to the tool, but it's meant to mimic human conversations. And so websites use these to try to answer questions that consumers may have. And so the Bureau took a look at the use of these chatbots in the financial industry. And there's actually quite a few financial institutions that have used this tool for quite some time, actually. And they have some fabulous statistics in this release as well, which I thought was very interesting, just and above themselves. But what the Bureau was trying to key in on is just a little bit of a caution in using the chatbots, that they have been successful tools when using simple questions or straightforward questions that need to be answered, but through some caution out there to users that sometimes when we have complex or maybe something that has several layers to the issue, that sometimes those chatbots are actually doing more harm than good. And they might be creating a larger customer service issue than what you had originally intended by using the chatbot in the first place. So a little bit of a caution there that depending upon obviously the particulars, but they're finding some trends where the more sophisticated customer service issues or answers or more tricky products and services that need to be explained, that the chatbot may not be the right solution for helping your customers through those questions and ferreting through to the right part of departments within the bank with that chatbot technology. So take a read of that issue spotlight, and make sure your marketing area is also aware of it, and kind of check your own history with what your chatbot is using and work with your technology provider to see, in fact, whether or not you have any worries or whether or not there can be some fine tuning to ensure that your answers that are being provided by that little icon is, in fact, answering your customer's questions accurately. The second item that we wanted to bring up, another issue spotlight by the Bureau, was twofold. There's the actual issue spotlight release itself, and then there's a consumer awareness piece that the Bureau had issued. And basically what they're doing is they're warning consumers about having monies on the various payment apps, the person-to-person apps, like the PayPals or the Venmos or the Cash Apps, just to name a couple examples, that these funds that consumers have sitting out on those apps may well be monies that are not FDIC insured, because they might be funds just sitting there at that payment provider and not actually in a account that has FDIC insurance behind it. Now, some of these products do have pass-through insurance, and so you're going to want to educate staff and ultimately educate your consumers to look at the details to see, in fact, whether or not those payment apps have an FDIC insured account or not. Most times they don't. But we wanted to make sure that you were aware of both of those issuances, that perhaps some consumer awareness piece might be able to be created back at the deposit or at your financial institution about deposit accounts, but certainly worth talking about amongst your frontline staff when they're engaging with their customers. And then the third CFPB item that we wanted to make sure you were aware of were some recent statements that were made by the CFPB of the likely intention of wanting to promulgate a updated rule to the mortgage servicing rules that we all work with. That through the pandemic, they found that some of those rules were kind of clunky. I think some of us would agree that they could maybe streamline some provisions of the mortgage servicing or find other ways to make it less paper intensive or fewer steps involved. And so they issued this announcement asking for a comment. And consumers can reach directly out to the CFPB. They're trying to gain interest in whether or not to promulgate an updated rule down the road. So just heads up, and obviously we'll have an opportunity to comment on that when we get to that point down the road. So those three things, the links are all provided for you below, including a separate link for the consumer awareness piece by their Bureau. So that's all the Bureau items that we wanted to make sure that were on your radar. And so then next up, we have also a few things to alert you to as it relates to guidance, examination guidance. So here on the slide, we have several items that were issued by the OCC, where we have an update to the asset management booklet within the Comptroller Handbook, and also an updated liquidity booklet in that Comptroller's Handbook. Now, these are helpful things because now you're going to understand what the examiners are looking for when they're examining for asset management or in liquidity standpoint. The asset management has been updated for various audit sections, and the liquidity has been rewritten a little bit for clarity purposes. The OCC has also updated its policies and procedures manual for enforcement. This came not long after the unfortunate closures of the larger financial institutions out on the coasts. And so they've set forth some updated examination and enforcement components when you have a financial institution that has failed to implement or has failed to address some of the persistent weaknesses that examiners have previously found in examinations. And then very quickly on the right side of your screen, you'll see that FDIC has updated its risk management manual, RMS, and have identified some new steps or some revision of steps as it relates to continuous examination. So this doesn't happen too often, but FDIC does have, as do the other examiners, have the authority to have an ongoing examination should the situation warrant. And so they updated some of those steps within that policy. So all of these items are links below for you to pull those specific updated resources from an examination front. So with that, Scott, I'm going to throw the program back to you.
All right. So our last item here is a slide with recent amendments to the Supreme Court rules for lawyer trust accounts. In short, just to start with this shouldn't change things majorly for your IOLTA accounts, but it's important to be aware of this when dealing with your lawyer and law firm customers. So the IOLTA rules have generally prohibited electronic transactions on these types of accounts, except for e-banking trust accounts, which were a new type of IOLTA account that were made available a few years back. Now, this new change that we're talking about right now will eliminate the prohibitions on electronic transactions for all such accounts. That means is that a lawyer or law firm will have more flexibility on how they handle client funds, either through continuing to use an e-banking trust account, if that's something that they had opened with you previously and used for electronic transactions, or through others now. So you might see your lawyer and law firm customers either continue to use their existing accounts as they are, continue to use their e-banking trust accounts, or maybe open new accounts or even consolidate their accounts. And really, this depends on what they determine is appropriate for their clients under these new rules. So the kind of big takeaway from that is that it's still the lawyer's duty to decide that. The lawyer, the law firm needs to decide what is best for the client funds, what is most appropriate, what account they want to use. They still need to maintain records and overall adhere to the rules. But if you have IOLTA accounts, you will have likely received a letter from OLR discussing this change, the Office of Lawyer Regulation, and providing some other specifics. But in summary, providing you with that as information. It's rather straightforward in what it is and what financial institutions need to do. But one of the items that it discusses is that you might receive a request from your customers, from your lawyers, to have a chargeback to the trust account be made through an operating account. So they might have these IOLTA accounts and they might request whether you have the ability for any chargebacks to that account to instead be processed through any operating account that they have that would be owned by their law firm or from the attorney themselves. So as to whether that's possible or it's something your customers might look for, we wanted to include that as something to be mindful of, because it's something that OLR is anticipating that your customers might be asking of you. These amendments are effective on July 1st, and there's more info in the link in the description below if you'd like some more of the specifics. Again, largely those specifics are going to be for what your customers need to know. But again, in doing business with them, it's important to understand that and important to understand the change so that when they come in and want to have that conversation, that you understand what occurred here. There'll also be an article appearing in this month's compliance journal as well. So take a look at that if you haven't seen it already. And with that, I will turn it back over to Heather.
Thank you, Scott. And as always, we want to make sure that you're aware of the various resources that we have made available to our membership through the compliance section on our webpage. So we always want to make a plug for the compliance tools and the resources that are out there, as well as our education department and our best practices library. If you've not been out there recently, we have some new items added to that library, including a pre-screening letter that the WBA Mortgage Lending Committee has recently released, which should help with your customers who are wishing to opt out of receiving pre-screening offers of credit or offers of insurance. Also, to make another plug for Scott, we have a Legal Live coming up July 11th that please see the education page to register for that. That's always a great resource. And Scott has a number of things that he wants to bring up that he's been hearing on the phones these last few weeks with the bankers, and it'll be well worth your time. So don't forget to set that up on your calendar and get yourself registered. And as always, don't hesitate to give us a call if you've got any questions that you've got about compliance. We're always happy to help. So don't hesitate there. And we look forward to seeing you in July. Hope everyone has a great summer so far. Take care.